Thank you for that introduction, and I would like to thank all the persons who put this conference together and sending the lakhs of emails to us, reminding us daily that the conference was coming. And at the end of the day, this is the largest IP conference in India, and I'm very happy to be a part of it, and I'm humbled to be asked to speak. And I would like to say something about Timothy's presentation, which I think was an excellent presentation, sort of a big picture view of those cases, right? It's easy to get lost in the details. He kind of gave us a big overview of why the cases are important, what impact they might have. I mean, that's one of the reasons we come to these conferences. That's the kind of stuff that you just can't get anywhere else. And I have to take one moment to sort of toot the horn of our firm, which is that our firm actually argued and won the Nautilus case at the U.S. Supreme Court. And it was a rare opportunity for me to hear from this litigator. I mean, these are real lawyers, these litigators, going into court and actually arguing. I'm a patent prosecutor, so I practice law behind the safety of my keyboard. And so that's what we'll be talking about today. And the topic that I chose is not very legally enlightening. It's actually a more, I think, a more popular topic because it's controlling costs. And we're all asked to do so. When I first started practicing law, it wasn't such a big idea to control costs. Of course, we had to do so, but now it's becoming a central part of our practice, and if we can't control costs, we lose clients. Now, I take a big risk here. You might think that we're trying to say that we're a low-cost law firm. That's not what I'm trying to say here. You'll see as we get into the presentation what I actually mean. All of my presentations are licensed under Creative Commons. That means you can make as many copies as you like, share them with your colleagues, share them with students. That's their copy left. So, here's what we'll be talking about today. First, some concepts. I'd like to get some vocabulary so that we can talk about this topic. There's some things that kind of help us understand and discuss the topic and figure out how to proceed. And then for those of you who don't know anything about patents, there's actually something for you to learn here, because I'm going to march through the chronology of a patent from cradle to grave. Now, I'm not going to cover anything to do with the litigation costs. That's another issue. But I'm talking about from a patent prosecution standpoint. So first, we have finding the inventions, filing on the inventions, right? Then we have the prosecution. Then we have post-issuance, and then we have those dreaded maintenance fees that we have to pay. And the theme that I have today is that you can have some cost reductions that will reduce the quality. But there are some cost reductions that actually won't reduce the quality and could even increase the quality. And so what you need to look at here is, okay, which of these am I going to take? Are there some cost reductions that I can do that will have a smaller impact than others, right? Rather than just sort of going to the lowest possible price. That's not what we're trying to talk about here today. So let's look at some of the concepts. First, what I just said, cost versus risk, right? You want to make an informed decision. There are certain things that you can do, certain things that our clients can do, certain things as in-house counsel you can do to reduce the costs, right? But you want to do so in an informed way. You want to choose to reduce the cost in a rational way. There are some things that clients will do, some things that the same client might be interested, different client might not be interested. And then I'd like to talk about addressing costs with the rules. There are some things that you just have to do. If you want to get the patent, you have to do A, B, and C. And I call those sort of procedural. And some of those things we can actually reduce costs on, but we have to do them. In fact, sometimes they're easy to reduce costs because we're doing them so repetitively. Then there are the issues of addressing the law, which I say are substantive issues. And, you know, this is really a difficult area to talk about, right? Because what we're talking about is the cost of fully understanding the invention, fully understanding the prior art, fully describing the invention, and then fully claiming the invention. And this is why it takes 20, 30, 40 hours for a patent attorney to put together a patent application, because this is actually a tall order. Right? I mean, if you think about what we're doing as patent drafters, we are describing something that no one else has ever described before. And that's our job. If it's something that has been done before, it's not going to get through the patent office. So we have to figure out what it is. We have to differentiate it. We have to put all kinds of layers of language in there. So that's sort of what's going on. And that part, well, you know, that part's a little harder to address, and I won't get into it too much, but that's part of the equation as to why the cost is so much. And for this next concept, credence services, I have to thank my law professor, Professor Lillian Bevere at the University of Virginia School of Law, who talked about this thing called credence services. And I thought it was interesting. First of all, there are some things that you can buy that you know what you're getting before you buy it, right? You can look at it, you can see what it is, and you know what you're getting. There are some things you don't know until you get it home, right? You have to open the package, see what it is, you don't know. Services are oftentimes like that. But there are some services that even after you pay for them and you get them, you still don't know what you are getting. And to a large extent, that's what patent lawyers do, right? It's very difficult to know. Even as a lawyer, you may lose your case, but maybe you had bad facts. You may win your case, and you just got lucky and got the right judge, right? So it's sort of difficult sometimes to figure these things out. We like to think that there's a value there, and we can provide it, but it's very hard to measure. At the end of the day, we have to be successful, or our clients won't engage us anymore. But this is part of patent valuation. And so I say that there are some things that you can do to at least make your patent appear to be more valuable. And if you're interested in reducing costs, one of the things you can do is educate yourself on patent valuation. This is something that could take an hour or 2 or 3 for me to talk about. So I'll just say let's touch on that. One of the ways of reducing costs is to increase the value that you get out of the patent. And then everything that I say here today is subject to an exception, right? I like to think I know what I'm talking about. There are clients who have goals that they override whatever I say. So you need to know those client goals, right? I have some associates who say, I went an extra mile for the client. And I ask them, that's very good, you went an extra mile. But did you go in the direction that the client wanted you to go, right? You might have spent all this money going off and doing something that the client had no interest in doing, right? So these are some of the concepts that we face when we're trying to control costs. So now let's go ahead and march through the chronology of a patent. First, you have finding the inventions. So you have an inventor incentive. I don't know how many folks do that, but oftentimes we will give the inventor an incentive for submitting the idea. So there's some cost there, and you have to figure out what that is. You might want to stage it. You give them a cost, you give them some sort of a monetary reward when they file the IDF. You give them another one when the patent issues. That keeps them engaged. You have to figure out what level that is. Maybe in your corporate culture you don't need that. You maybe have a university and you don't need to give people an incentive because they want to. It's different. It differs. Then you have a patent review committee, typically a filter to filter these inventions that are coming out. And I say there's a big risk here that people overlook, which is the rubber stamping. Okay? The patent review committee that simply takes whatever the inventor gives them and passes it on to the patent drafter. The big risk here is that you're going after something, you don't know what it is. It may not be important to the company. It may not be well described. It might not be described to the point where you can actually make a decision. And then when you have the disclosure meeting, it turns out to be something entirely different, and then there's no direction that's going, or it's a very thin invention, and you end up filing on something that's not of any value to the company. So there actually is a value in having a patent review committee that takes some time to figure out and to push back and say, we need more information from the inventor before we can make the decision. We'd like to file a patent application on this, but we don't really understand what it is. Then you have combining inventions into one application. I like to say this is like going to a tea stall and you have a cup. And you ask for 1 cup of tea, and they give you a cup of tea. Now you say, I would like another cup of tea in the same cup. Well, what happens, right? You pour the tea, you might get a little bit more tea, but generally most of the tea sort of pours over and goes all over the counter. Well, this is sort of what we are asked to do as patent drafters on a regular basis, is to take 2, 3, 4 inventions and stuff them into one application. And you know what? We will do it, and we will do the best job we can, and we will continue to do this because this is what our clients want. There's a risk here, though, right? Because what happens, particularly if you have a large patent portfolio, these things turn into widgets. They start going down the assembly line, and nobody remembers what the 2nd, 3rd, 4th inventions were. They get passed among firms, they get passed among people. You know, this is what happens. And then you have the situation where you've actually claimed one thing, but you haven't claimed the other. You've dedicated that to the public, right? They'll say, well, put it in a dependent claim. And we can do that, and we certainly will do that. But remember that process I talked about? Understanding the invention, understanding the prior art, claiming the invention, all those things. Well, you know, if it's trying to cram all that information into one application, that can be difficult to do. There's also searching. Most of our clients search. We have a few clients who don't search. I think that's another filter, right? That's a way to reduce your costs, is to cut the case completely. Why continue with a case? So I would say if you have someone drafting patents, be open with them, communicate with them, and encourage them to pull the plug on bad applications. If you have an application that is just sort of very thin, hanging by a thread, encourage your patent drafters to come back and push back and say, look, I know you said you wanted to file something on this, but there's very little here. Lawyers are sort of reluctant to say that type of thing in writing, in an email, so you might have some sort of a procedure where you say, well, give us a call, or set up a meeting request and we'll talk about issues that have to do with the application, and that way you can possibly pull the plug. On the other hand, you reserve the right to continue, right? Because sometimes there's a business reason. You want a patent for a licensing purpose. And that's fine. We can go back and collect more details as a patent drafter, which is primarily what I'm doing. I can go back and collect more details, and I can get a patent, right? 98% of the time, we can get a patent. It just might not have any value to you, or maybe the goal is it's a patent number, and that has value. Now, this is the area where I think we can really get some low-hanging fruit when it comes to reducing the costs, and that is looking at filing on the inventions. This is a mechanical, repetitive process, and you should develop a working relationship with your patent filer, and you can get these things done. We oftentimes have clients that are sending us cases, or foreign associates are sending us cases, and they just want them filed. And or they're preparing their own applications or what have you. To do that and to contain costs, you need to understand the U.S. government fee structure. And that is, you get 3 independent claims, 20 total. If you file more than that, well, if you know what you're doing, that's fine. But if you didn't realize what you were doing, you could very easily be throwing money away. If you file a case with 10 independent claims and you pay the thousands and thousands of dollars of independent claims fees, the excess claims fees, the U.S. government thanks you. But they will not examine the claims. They will restrict the application into pieces, and they will only look at one piece. And so now you've taken that money and you've essentially contributed it to the U.S. government, which thanks you, but really won't do anything for you. Then you have the multiple dependent claims. I've done the math. In the United States, it never makes sense to have a multiple dependent claim, other than you're rushed, and or you don't want to pay someone to turn them into multiple dependent claims, but it just doesn't make any sense to file those in the United States from a financial standpoint. Page counts. You get 100 pages, 133 if EFS. So typically what I say there is, you can modify the font size, right? You can go down to a smaller font than 12 point. It seems kind of silly, but that's one way you can save some money. And if you do it on a regular basis, it can add up. There's also small entity. I'm sorry about the microphone situation. I have trouble standing in one place. You have the small entity situation, which actually gives you a 50% discount, and the micro entity, which gives you a 75% discount. If you can avail of these, you can see you can save a considerable amount of money. So this is something that you're definitely going to want to do if you have individual inventors, universities, anybody who qualifies for this. These forms are available for you on the USPTO website. You can fill them out, provide them to the attorney, and that way you save even more money because the thing has been completed. Then we have declarations. Declarations are required, but we oftentimes have them unsigned, and that's a problem. It's okay in some situations, okay, you couldn't get the signature, but let's say you're filing a Paris Convention application. You knew a year ago that you're going to file this. You knew a year ago that you're going to have the declarations. I don't mean to take an admonishing tone, but what was the purpose for that? Why not have those declarations? Because then we have to chase after the inventor. The inventor goes to work for another company. The inventor becomes difficult. The inventor becomes uncooperative. We could spend hundreds of dollars trying to find the inventor, who then signs it, but signs it incorrectly, and then we need to go, and you see all that. So it's much better if those declarations can be signed and presented at the time we file the application. So not only do you avoid the government fees, you avoid the headache and the logistics and the possibility that they disappear, and then you have to pay some big fancy fee to explain why the inventor disappeared. Then you have power of attorney. You can file in the name of the company in the United States now and reuse your powers of attorney, so you don't need to have the inventor signing these documents, and that's one way to reduce costs. There is a stealth cost to that, and then it's very easy then for folks to search and publicly see your patent portfolio. So maybe you decide you don't want to do that because you want to try to remain anonymous, but if that's not a concern, then you can save some money there. Also, the details that we need. We need the inventor, family and given names, and we need the resident city and country, and state if they're in the U.S. Please don't give us the state if they're not in the United States. It will confuse our people. They don't know if it's a state in all the states and all the different countries. So this is something that keeps it very simple, and you will learn this as you work with counsel to very easily maybe fill out a form for something like this so the information can be communicated accurately. We've also had situations where we're giving them a misspelled name. Seems like a small idea, a small problem, but then if you need to actually communicate that in several countries because the application has been filed all over the world and it's a bigwig inventor who wants to correct it, you end up in some trouble. So these small, boring, excruciatingly boring details actually can make a difference in the cost that you pay. And I see these things on a fairly regular basis, which is why I'm bringing them to your attention. And always use EFS with an ADS, and that's electronic filing system with an application data sheet. If it's not required, it should be, because it certainly reduces the number of errors that you encounter. The Patent Office can't mistype or misenter the information. And filing electronically is great because the Patent Office can't lose the file. Then you get to prosecution. We have clients who routinely tell us to ignore publication. There are some risks there, but it's something that's a rational decision to make. And or you have a team in India that proofreads the application instead of having a fancy law firm do it. Then you have RCEs, and this is the part where I would like to spend a little bit of time on, because this is the #1 big expense. And unfortunately, our experience as patent prosecutors is that you can expect to probably file at least one RCE. We will try to avoid it, but you should plan for it. If you're planning the cost of filing a patent application and you need to let your accounting department know how much it's going to cost over the life of the patent, you should probably include one of those. And those are, depending on your entity size, $1,200 to $1,700 if you file second and subsequent ones. There is something called the after final consideration pilot. No additional government fee for that one, so that's something that you can use to try to avoid the RCE. Doesn't always work, but that's something that you can use to reduce cost. Then we have this concept called bracketing the invention. And this is a legal concept. This is more of a legal concept than a financial concept. And that is, we oftentimes have attorneys who put together their patent application, and they essentially have one point, their broadest independent claim. And they argue and argue and argue about that one point. The problem is, it's difficult to come to agreement on the one point. Now, I know that examiners are supposed to look at dependent claims. Well, let me tell you, they're very busy, and oftentimes they have to handle the dependent claims, but they're just sort of ritualistically rejecting your dependent claims. To have another independent claim with different scope provides a range of options, really encourages some discussion with the examiner, and makes you think about the case in such a way that you're much more likely to get advance of prosecution. The risk? You get narrower claims, right? Because now you've presented options and the examiner can pick. But let me tell you, if you want to reduce costs, you're probably going to end up with narrower claims. Not always, but that's sort of one of the things that happens when you reduce costs, is you end up with narrower claims. Spending more effort per office action. We had a client who did a study. Spending more per office action reduces the overall cost, because you're not just kicking the can down the road, you're actually trying to figure out what's going on. You're talking to the examiner, you're putting a face on the case, and then you actually get the thing allowed rather than having to file 3 RCEs. So that's something that we encourage, is spending a little more per office action so that you end up spending less overall. And then there's cross citations and information disclosure statements. I'm not going to talk about that too much, other than to say that there is some cost there. We're almost to the end now. We're looking at post-issuance. There are a lot of things that you can do after a patent issues. You can proofread it, and there are case laws out there saying that you must proofread it, because if there's an error, a fatal error that affects one of the legal requirements, your damages don't start until you correct it. But we have clients who say, no, that's a risk we're willing to take. We don't want you to proofread it. And or we send it to some low-cost group of people who can proofread it rather than having the attorneys do it. You have a broadening reissue deadline. After 2 years, you can't file any more broadening reissues. But do you want to pay your attorney to tell you that? You might not care. There's also patent term adjustment. Just a few months ago, we had a case where the patent office got the patent term adjustment wrong. It was incorrect. We went back, we recalculated it, we filed a petition, and we were able to extend the term. But do you really want us to do that? Do you really want us as patent prosecutors to go out and look at every one of your cases and see whether or not there's patent term adjustment? Maybe not. You know, maybe the invention 10 years from now, you just don't care. So that's something. There are all kinds of risks here if you don't do these things, but it might be a rational decision for you to make, and you decide, if you're taking that informed risk, that you, or you maybe identify some cases you do this, but the default is to not do it. And that's one other way we can do it. And then finally we come to the end, maintenance fees. You have to plan to pay the maintenance fees from the beginning. Otherwise, you're like the teenager who goes out and buys the expensive car with their last dollar and then doesn't have any money to buy insurance, and then they can't drive the car. And it's sort of similar. You don't want to have yourself placed in a position where you're panicking, looking for some way to cut costs because the planning for the maintenance fees was not put into place. And so we know in a